Hello, students. Let's chat some about our judicial branch. So, we know what we know about our judicial branch from the Constitution in Article 3. And we know some of the background logic of Article 3 from reading Federalist Paper number 78, which you can Google very easily and may be able to find in your appendix even. And in that paper, Alexander Hamilton argues that the judicial branch is the least threatening of all the branches because it has neither the force of will nor the purse, just judgment. It doesn't have the power of taxation like the Congress does. It doesn't have the power of force like the executive branch does. It has only judgment. We borrow a lot of our judicial system from the British system of common law. In fact, our common law system is still linked through the British system, such that if you're a lawyer researching certain case law, you might even reference some case from 1400 Britain. But common law means that future decisions, or the decisions today, are based on past decisions, and we build up case law in a common tradition such that we figure out how to decide today's cases and today's facts based on how similar cases were tried and decided in the past. That's why being a lawyer in many ways is about finding the appropriate case law and arguing how those results apply in the current setting. Article 3 is vague like Article 2 and not specific like Article 1. Article 1 that deals with Congress goes step by step through the things Congress has the power to do. Article 2 about the presidency says all the power is vested, and the same way in Article 3 it says all the power of judicial stuff will be vested in a Supreme Court and whatever inferior courts that Congress makes later. We know that justices serve for life. You might want to muse on why they serve for life. What are the benefits for having a justice serve for life? I bet you can come up with several good reasons. So what are the checks we have in the Supreme Court? Well, the president nominates who the justices will be, and the Senate confirms it. So there's the connection with those other two branches. Also, the Supreme Court has no enforcement. There's no police force. So it just makes up a judgment, and it's up to the executive branch to fulfill it. So it has very little power in that sense. The Supreme Court can say all schools must be integrated, but they have no power to make that actually happen. Judicial power comes from four main sources, at least constitutionally speaking. We have that Article 3 statement that we will have a Supreme Court. That is our constitutional authority. We have the Judiciary Act of 1789, which established all our other courts. We call that legislative authorization. And we have the power of the court established in Marbury v. Madison to decide if a law is constitutional or not. That power we call judicial review. And the fourth one, maybe the most important, is prudential practice, meaning the court has been careful not to tick off the majority too often or make too many controversial decisions. And so over time, we, the majority, look back and we say, okay, they've told us sometimes that we were wrong, and they seem to have been right. Things like civil rights and segregation and all those kinds of decisions. We say, at the time, we, the majority, we were doing something wrong, and we see that you were right. And so through this prudential practice, we have a lot of faith in the Supreme Court, and it usually rates very high on scales and ratings of public competence. So early on, the court was not very effective. In fact, they couldn't even get enough justices to show up to hold the first session. So if you're thinking in terms of the three bubbles, the E bubble of the executive branch, the L bubble of the legislative branch, and the J bubble was the smallest, just a little blip. Luckily, John Marshall comes along, after who my dog Marshall is named. Not that you need that, but it's true. He's probably the most important justice we have on the court. He served for a ton of years, and he did a lot of things that strengthened the court. One example is he discontinued seriatim. Seriatim was when judges would speak one at a time about their decisions. Now the court speaks with one majority voice, and sometimes a minority voice, as the Chief Justice allows. He also established the court as the final interpreter of the Constitution through this case of Marbury versus Madison. One of those pictures of Marshall on the right is my dog, and one is the actual John Marshall. But this court case is an interesting case where Marbury wanted his appointment delivered, but the party controlling the White House had changed. And the new Secretary of State, James Madison, was like, I'm not delivering this appointment to Marbury. Forget him. So the court was in a really difficult position because there was a part of a law that said the court could make James Madison deliver Marbury's appointment. But if the court did that, they knew Madison was just going to ignore it, and that would further weaken the court. Of course, if they didn't do it, it just looked like they were afraid of Madison not doing it. So, in a stroke of genius, really, Marshall's decision was that yes, Madison should deliver it, but the part of the Constitution giving that not the Constitution, the part of the law giving the judicial branch the power to order Madison to do something was unconstitutional and needed to be struck down, because you couldn't have one branch having control over another branch. If the judicial branch could just tell people in the executive branch what to do, that's not separation of powers. So this case avoided weakening the Supreme Court and also provided the court as the power that would decide judicial review. This judicial review means saying, okay, you made a law, majority, but that law violates the constitutional rights of something and therefore cannot exist. We have a dual system in America in that we have a federal court system and we have a state court system, and they are mirrored. They have 3 tiers. In the federal section, if you break a federal law, you go to district court, then there's a court of appeals, and then there's the Supreme Court. On the state level, you go to trial court first, then there's a state court of appeals, and generally a state Supreme Court. So that is our court system overall. We care here mostly about the federal courts because we don't have time to talk about all the ins and outs of all the other legal system. And we care about jurisdiction. Jurisdiction is the legal sphere of influence. Who has proper authority within a given sphere? So if you break a federal law, that is federal jurisdiction, and you go to federal court. Much like any cop show you've ever seen, if you break a local law, that's the police. If you break a county law, that's the sheriff. If you break a federal law, then the feds come in and the local cops go, oh, the feds are here taking over our investigation. Those are all matters of jurisdiction. We also have 2 basic kinds of law. We have criminal law, which is you violated some rule the state made. So that case sounds like state of California versus O.J. Simpson. And there's civil law, and that's when you sue somebody. So criminal law results in potentially prison, probation, fines. Civil law always ends in some monetary amount. And remember how important precedent is for us because we have a common law system. Precedent being how have previous cases been decided with similar sets of fact. And this Latin term stare decisis, meaning let the decision stand, is a motto of common law systems. That precedent will be really important. The Supreme Court gets petitioned to hear a ton of cases every year, about 1,000, but they hear less than 100 each year. And the process of deciding which cases to hear is kind of complicated. Essentially, if 4 out of the 9 Supreme Court justices want to hear the case, that's the rule of 4, it gets put on the docket. The docket is the list of cases that will be heard. There has to be an actual dispute. It can't just be a hypothetical situation, though some state Supreme Courts allow that. I think the Massachusetts State Supreme Court may have made a hypothetical ruling about gay marriage in the last few years. In fact, both of the people involved in the case have to have standing. That means they are adversely affected by the outcome. For instance, Brown versus Board of Education, Brown was an actual student. The NAACP would love to have tried that case on their own, but they needed somebody with actual standing, somebody with stake in the case, and that was why Brown, the student, was the actual party. There has to be something that can come out of it, some actionable decision. The court's not going to waste its time with a bunch of controversy just to tick the majority off and have nothing happen. That's part of its prudential practice. And generally, cases come either up through the federal system from the Court of Appeals, over from state Supreme Courts if it ends up being a federal constitutional matter, or it has something to do with the 3 bubbles, the 3 branches of government, like Marbury versus Madison, and when it has something to do with those branches of government, it comes right into the Supreme Court. So the President nominates and the Senate confirms. That's the process for finding federal judges, but it's not just the Supreme Court. That's true for all federal judges everywhere. So the President can have a pretty big impact on what the court system looks like. Each justice has a clerk that does a lot of the minion work, does a lot of the first drafts, does a lot of the memos to help select cases, and clerks are really important. There's sort of a secret role of clerks that exists. Now, thinking about judicial philosophy, there is this idea of strict constructionism, and a strict constructionist would say you must interpret things based on the letter of the Constitution without any interpretation. Then there are those Supreme Court judges that say the Constitution's really old. There's no internet in the Constitution, and so it needs to be interpreted somehow. Those are two sides of a philosophical spectrum. Those saying no, it should be letter of the Constitution. Those saying no, we should interpret what they meant. What is the intent of the founders? Another spectrum of judicial philosophy is activism versus restraint. How active should judges be in selecting cases that right things that are wrong in society? Restraint says, let the majority take care of most stuff and we'll take only the important stuff. Activism says, no, we should be actively looking for injustice out there and solving it. Here are the pictures of our judges. See if you can name them. Can you name them? This is from most recent, top left, circling around the right to the oldest, which is the bottom, and on the exact right, that's Scalia. Can you name any of the others? Can you? Here are their names and the dates they were confirmed. We have the newest member, Elena Kagan, and Sonia Sotomayor. Both are Obama appointees. Sam Alito and John Roberts were Bush appointees. Stephen Breyer and Ruth Bader Ginsburg are Clinton appointees. Clarence Thomas is from H.W. Bush. Anthony Kennedy and Antonin Scalia from Reagan. We can often say that the judicial branch has some role in policy making in that they can overturn laws and shape the way laws are interpreted. And we have to wonder about the influence of ideology. Does being a Republican or being a Democrat, how much does that influence how you decide court cases if you're a Supreme Court justice? We also wonder how powerful the court is. Does it have enough power to counteract the power of the majority as the majority makes up weird laws like everybody named Steve must be banished from America? Well, hopefully the court steps in and says, no, that's unconstitutional. You can't have that law. Fortunately, because of prudential practice, our trust in the court is very high, and that's important for the Supreme Court considering they don't have any enforcement of their own. They count on the fact that Americans trust the Supreme Court and will require the President or Congress to fulfill their wishes. Let's pretend you're a justice. Are you glad to serve for life? Why? Some more questions you should consider. Should cameras be allowed in the Supreme Court? We currently do not allow cameras in the Supreme Court. We do allow cameras in other courts. That's how we have things like Court TV. Would being a Democrat or Republican affect your decisions? And would you be a strict constructionist, or would you be more of an interpretivist? Original intent person, somebody who says we need to understand the original intentions of the founders. Will you be an activist, or will you practice judicial restraint?